Thank you, Madam Chair. I will represent to you the viewpoint from the Icelandic fishing industry. First, let me say that the Icelandic fishing industry supports responsible fisheries and effective fisheries management based on scientific research and advice for conservation and sustainable use is crucial. And this, of course, applies to all living marine resources. Also, let me say that Europe is important to the Icelandic fishing industry. We wish to have continued good cooperation with Europe. It's very important to us. And as has been amply documented here today, European markets are important to Icelandic interests. Despite this, it is our position in the Federation of Icelandic Fishing Vessel Owners that we oppose Iceland's EU membership. And there are a variety of reasons for that. The first one, and a very important one, is that we would lose control of one of our most important resources. By joining the EU and adopting the common fisheries policy, Iceland would lose control of one of its most important natural resources, and that is a very heavy burden that we don't find acceptable. Legislative powers would shift from Iceland, and you heard today the story about how we fought for control of our resources. Iceland has sovereignty within its 12-mile limits and also within its 200-mile exclusive economic zone. The most important part of that sovereignty is the power of lawmaking and enforcement of the law. If in the EU, the legislative powers would shift from Iceland to the European Council, according to the Treaty of Rome from 1957. We feel it is very important because we have the vital interest, we have the knowledge and experience that comes with the closeness to the resource, and we believe that it's crucial that management should be close to the resource, close to the vital interests. Now, what would our position be? We would presumably have 3 votes out of a total of 348 within the Council of the EU. And you know all of this, within the Council of the European Union, we would need an increased majority for decisions to be voted in our favour. We, of course, have had visits to our office from the EU and from people discussing the issue, and the Luxembourg Agreement is often mentioned. We believe that the Luxembourg Agreement is too weak to guard our interests, if you compare that to having legislative authority and management. So we consider that the Luxembourg Agreement, which calls for reconciliation where exclusive national interests are at stake, to be too weak to guard Iceland's interests in the fisheries. Here I have the text of the core of the Luxembourg Agreement. Most of you will know that, but it's here in the slides for those who wish to look at it. We are not optimistic about permanent exceptions from the common fisheries policy. It has been debated whether exceptions from the CFP are possible, obviously. However, history tells us that the CFP is upheld without any permanent exemptions. For example, in 1994, Norway came away from EU negotiations without anything noteworthy in our opinion. No permanent sovereignty on fisheries management within its EEZ, only a 3-year exemption for fisheries north of 62 degrees north, and a 1-year exemption south of 62 degrees north. We are often told that the rule on relative stability should guard our interests. Nevertheless, we have no guarantees for an unchanged rule on relative stability. Despite the best efforts, Norway could not obtain a guarantee that the rule on relative stability would stay intact. And the EU did not accept Norway's demands for exclusive rights to its marine resources within the EEZ. So we have looked at that precedent. We would have no direct representation in important UN negotiations on fisheries issues. This has been discussed here today. I would just like to add that Iceland's voice has on occasion been important for the outcome at both the UN General Assembly and the FAO and in other fora. And again, this comes from the knowledge and experience provided by being close to the resource and having the vital interests. EU's exclusive competence on marine biological resources, referring you to the Treaty of Lisbon from 2007. This exclusive competence does not improve Iceland's chances, in our opinion, of an acceptable agreement on fisheries with the EU because of the exclusive competence article. And the wording of that relevant part is there on the slide, and you're all familiar with it. So that is a serious concern in our view. Now, the EU would negotiate for Iceland on the management of straddling stocks, and they are extremely important to us. And it's the management and distribution of fishing rights for these stocks that we're talking about. And around 30% of the Icelandic fishing industry income comes from harvesting these stocks. And this is an ongoing issue. It's an ongoing task because there are changes in distributions, changes in stock size, changes in climate, etc. And nothing is cast in stone in that regard. And it's very important to us to have this right. Now, on the economic side, this has also been mentioned, but abolition of domestic limitations on foreign investment. Currently, to maximize the local economy's benefit of the industry's revenues, domestic law imposes limitations on foreign investment in the Icelandic fishing industry. Upon joining the EU, this law would probably have to be amended to comply with EU law. And we have not seen examples that convince us that rules on this topic could be adequate. I should also point out that the rule on relative stability can work to our disadvantage. And the obvious case in point, of course, is the mackerel. Had we been members of the EU when the situation became that we had a substantial, unavoidable mackerel bycatch in our herring fishery, we would not be allowed to land that that mackerel catch. So we would, if I understand the situation correctly, have been obliged to discard the mackerel, which we find, well, I'm not going to pick any words for it, but certainly unacceptable. We all know that compliance to common fishery policy rules entails discarding of fish. And if in the EU, Icelandic fishermen would have to comply with the rules of the common fisheries policy. And this applies to all fish in excess of quota allocation and all fish that does not meet minimum size requirements. Now, discarding is prohibited by Icelandic law, and in my opinion, it should be prohibited by law everywhere. Profitability and sustainability, or the negative effects of the common fisheries policy, that is the question. Our fishing industry operates with the objectives of profitability and sustainability, while the EU heavily subsidizes its fishing industry. This has been discussed before here today, and with the emphasis on the importance of the fishing industry to the Icelandic economy. The effects of the common fisheries policy have proved to be negative, with overfishing and depleted stocks, operational losses and government subsidies. This, of course, is nothing new for you to hear. This has been amply documented and well presented by your own institutions, and you deserve credit for honesty in that. So I will end this by listing 10 important reasons why Iceland should not join the European Union. These are the reasons that I have gone through. I should add that this is the short list. There are, of course, other reasons in our opinion. So this is basically all I have to say. This is just a frank statement of our position towards this topic. Thank you very much.